Thank you for the opportunity to speak today. I appreciate very much the purpose and goals of this committee in trying to create solutions for preventing the weaponization of state government. I've closely studied the emergency power laws in Michigan and the COVID-19 response that we underwent in 2020 and 2020. And I've learned quite a bit about how emergency powers function in Michigan and how we can improve our response to the next pandemic if that occurs. And there are four key takeaways from my presentation that I want to provide today. The first one is the separation of powers guards against the weaponization of state government. The second is unilateral executive control violates separation of powers and paves the way for government weaponization. Third point is that Michigan officials may grant themselves unilateral control with the stroke of a pen via emergency powers. And finally, policymakers should make and enforce an emergency pandemic plan. So to the first point, separation of powers guards against the weaponization of state government. What is the purpose of the American tradition of governing through a separation of powers? The founding fathers committed to this not to make government more efficient or just or representative. They committed to separation of powers to prevent what this committee is contemplating right now, to prevent the weaponization of state government. The Michigan Constitution makes this very clear in Article 3, Section 2, it reads, "No person exercising powers of one branch shall exercise powers properly belonging to another branch, except as expressly provided in this Constitution." Notice how absolute and complete this prohibition is. No person, except as expressly provided in this Constitution. This is meant to be ironclad. Weaponization of government often occurs when one branch of government, and it can be any of the three branches, gains too much authority that unbalances the powers shared among the branches. Respecting separation of powers means balancing these authorities and clearly delineating government authority. Without it, one branch could use its expanded authority for something other than fulfilling its public duty, which is a form of weaponizing government. And to my second point, the biggest threat to the separation of powers is the use of emergency authority. One of the most dangerous violations of separation of power is the inappropriate use of emergency authority by the executive branch. This is a lesson from the COVID-19 pandemic response. The Whitmer administration exercised an unprecedented level of unilateral lawmaking authority for about 18 months. The administration easily sidestepped a Michigan Supreme Court ruling meant to restore checks and balances. The use of emergency powers does not always lead to weaponization. Many emergency power laws in Michigan limit the authority and the duration that the governor or a state official can use these authorities or this emergency authority for. But Michigan law contains several emergency powers that permit state officials to exercise expansive unilateral control for long periods of time. And some of these emergency powers even allow them to exercise this control indefinitely. I reviewed the entirety of Michigan's laws and identified every single instance where there was some granting of emergency authority to the governor or to a state official. I found about 30 different laws in statutes that do that to some extent. Fortunately, many of these laws, most of them, properly limit the authority of a state official or the governor when using these emergency powers. But there are three big ones that provide a dangerous level of unilateral authority to the executive branch. These are the epidemic powers granted to the state health director in the Public Health Code, the emergency rules contained in the Administrative Procedures Act that any regulatory agency can use, and the governor's broad authority in the Emergency Management Act of 1976. These allow the governor or the directors of state agencies to act unilaterally as lawmakers, to take on the proper role of the legislature. The governor's power under the Emergency Management Act is maybe the least worrisome emergency power that we have, because the governor can only act unilaterally for 28 days before needing legislative approval to continue. The legislature could, however, expand or extend this emergency authority of the governor indefinitely. There's no limit in the statute for how long legislative extensions of this authority could last. It could, and the statute could be used for virtually any situation. The text of the statute does list several occurrences, which are examples of things it could be used for. So it lists things like floods, fires, tornadoes, infestations, explosions, etc. But it also says that it is not limited to that list. So theoretically, the Emergency Management Act could be used for any situation that the governor thinks requires emergency action. The Administrative Procedures Act, under it, state officials may grant themselves unilateral authority to issue emergency rules that have the same force of law for up to a year. Departments can use these emergency rules to give themselves sweeping powers that they would not otherwise have. During the COVID-19 emergency, for instance, MIOSHA issued emergency rules that regulated every interaction that took place in every Michigan workplace. The department actually even tried to make these emergency rules into permanent rules at one point. The legislature almost certainly never intended to give MIOSHA this level of power, but under its broadly worded statute, MIOSHA could grant itself the ability to regulate every employer and every interaction in every Michigan workplace. The epidemic powers in the Public Health Code are the most dangerous, as the statutes provide virtually no limit to their use. The health director used them to regulate every social interaction in the entire state during the COVID-19 pandemic. So it allowed the director to close schools and businesses and churches, restrict family gatherings, force parents to mask their toddlers, and subject healthy teenage athletes to weekly testing. Virtually anything could be done under the statute. These big three emergency power laws are problematic, not only for their sweeping lawmaking authority they hand over to the executive branch, but also for how easily they can be triggered, how easily they can be used. Which leads to my third point, that Michigan officials can grant themselves unilateral control with the stroke of a pen via emergency powers. The parts of statutes that describe the situations under which emergency powers can be used, I refer to those sections as triggers because they provide a trigger for when the executive branch can use this authority. These triggers define the conditions and situations that allow unilateral control. If governors and other government officials could act as lawmakers just whenever they chose, they would be exercising unconstitutional legislative power. Many emergency powers laws in Michigan have inadequate triggers, but the broadly worded and ill-defined ones in the Administrative Procedures Act and the Public Health Code are particularly troublesome. The Administrative Procedures Act's trigger reads like this, quote, if any agency finds that the preservation of the public health, safety, or welfare requires promulgation of an emergency rule, the agency may dispense with all or part of the procedures and file an emergency rule. This is all that is required. So none of these important terms here that I've bolded are defined in statute anywhere. So what it means to preserve the public health or safety or welfare is left entirely to the discretion of agency directors. And there's no other requirements. So it is entirely within the discretion of the director of an agency to determine when there is an emergency and determine when emergency rules are required. This effectively means that state agencies can give themselves this power anytime that they want to, anytime they want it. Department directors have full discretion to determine when emergency rules are necessary. They can simply declare that a public health or safety or welfare requires emergency action and then unilaterally issue new rules. The scope of these rules that agencies can issue under emergency powers is limited in one sense. They can only create rules about issues that they are legislatively permitted to regulate. However, the statutes that permit agencies to promulgate rules are often very broadly worded. So for instance, the DNR, for example, may, quote, promulgate rules to protect and preserve lands and other property under its control from depredation, damage, or destruction. It's a very broad description of what it may do. The health department's scope of authority is even broader. It can promulgate rules to, quote, safeguard the public health. That's all the requirement. A good example of an expansive use of these emergency rules is not from the COVID pandemic, actually, but right before it, when Governor Whitmer tried to ban flavored vaping products in 2019. To achieve this, state officials declared youth vaping to be a public health emergency in Michigan. This allowed the department to unilaterally and immediately ban flavored vaping products from stores. Amazingly, the health officials failed to cite a single statistic about how many people were harmed by flavored vaping in Michigan. But it didn't matter because all they had to do was declare it a health crisis. Nothing else in state statute, to my knowledge, gives the health department the authority to ban otherwise legal products or to regulate what legal products retailers can sell. But by declaring a public health emergency, now the health department can grant itself the power to regulate those products. By the way, those emergency rules didn't last long. They were in place for about a month before a court stopped them, and they were eventually the law process, or the legal controversy about them was settled about a year later. But they are a good example of an expansive use of these emergency rules. The health department is not alone in misusing emergency rules. I went back and looked at when these emergency rules were created in 1979 through the Administrative Procedures Act. And almost immediately after the law was passed, a State Department, I think it was a LARA maybe, or a predecessor to LARA, they issued emergency rules to require real estate agents to register with the state. Okay, what they really wanted to do was they wanted to implement this policy quickly and give themselves time to create permanent rules. But there's clearly no connection between whether or not real estate agents register with the state and the public health, right? So there's a long history of agencies using these emergency rules for things unrelated to public health. The public health code trigger is even broader than the one that's in the Administrative Procedures Act. It says that the health director can grant himself or herself unilateral control if the director determines that control of an epidemic is necessary to protect the public health. The statute does not define the important terms in this text: control, necessary, protect, public health. None of these things are defined in statute. Even the term epidemic is not defined in statute. This means that the director has broad discretion, lawmaking authority under the statute is necessary. And by the way, local public health officials have this exact same authority. They can grant themselves unilateral control and issue orders related to epidemics that apply to their local public health district. A good example of an expansive use of an epidemic order, there's many examples from COVID-19 pandemic, but a good one came from October of 2022. Now think back to October 2022, what was happening with the pandemic? Well, it was over by then. In fact, the Biden administration had just a month before kind of formally announced the end of the COVID-19 emergency. Nevertheless, the health department issued an epidemic order that stated that control of an epidemic is necessary to protect public health, And it also stated that the COVID-19 pandemic continues to constitute an epidemic in Michigan. This is despite the fact that the Biden administration said the pandemic is over. The department also had no other regulations or rules in place to try to control this supposed ongoing pandemic in October of 2022. And the order that they created then, all it did was require nursing homes to offer COVID shots to residents. So there was no connection between public health and this order, and there was no pandemic going on to justify the use of this order in the first place. So this epidemic order, its use is, to say the least, a stretch of these powers. And this is not how government is supposed to function. If the state health department wants to mandate that nursing homes offer residents COVID shots, they can do that, but they need to follow the normal rulemaking process. That process is there for a reason. Administrative agencies are not meant to have the authority to issue dictates just whenever they think something is important. Our government is designed to require that these types of mandates can only be created after deliberate and thorough review. That might frustrate policymakers who want to get their will done quickly, but it is a vital part of our checks and balances system, and it protects the separation of powers. The Public Health Code's epidemic powers are so poorly designed and broadly worded, that statute, that policymakers should prioritize limiting these powers. Which leads to my last point, that policymakers should make and enforce an emergency pandemic plan. The Public Health Code's grant of unlimited epidemic powers is ripe for abuse. One area of concern is that the power it authorizes is not necessarily limited to influenza pandemics or other contagious disease outbreaks. The statute lacks meaningful definitions of any of its essential terms and could theoretically be used for any number of issues. Increasingly, we hear this, social problems are described to us as epidemics: obesity, opioid use, bullying, homelessness, gun violence, loneliness. We've all heard these things described as epidemics. Public health officials describe them as epidemics, actually, as well. And increasingly, protecting public health is used as a rationale to restrict individual behavior and choices with more rules and regulations. So it is not beyond the imagination to think that these epidemic orders could be used for something other than an influenza pandemic. There are three other problems with the epidemic orders. The first is that it creates such a broad scope of authority by lacking meaningful definitions for the government actions that it permits. That means the director can use these powers to regulate virtually anything. During the COVID pandemic, these orders were used to control who you could host in your own home. I can't think of a more invasive rule than one that restricts who I can associate with in my own house. Furthermore, the statute includes this line, quote, "Emergency procedures are not limited to this code," end quote. This appears to give the director additional unspecific authority that exceeds even the public health code. The second problem with the epidemic orders is that there's no durational limit on how long they can last. So these could theoretically be indefinite. In fact, during the COVID-19 response, there were several orders that were issued that did not have an expiration date, and they were to expire only when the health director said they expired. They could theoretically last forever. The third issue is that there are no procedural requirements for issuing these epidemic orders. Many emergency powers require state officials or the governor to follow a defined procedure before they can take unilateral authority. The Public Health Code provides none. The health director can issue these orders at any time, at a moment's notice, with the stroke of a pen. There is no built-in oversight or check on the use of these broad and easily abused emergency powers. Policymakers need to address this problem before the next pandemic emerges. The Michigan Supreme Court, unfortunately, had the opportunity to address whether this statute was constitutional, but just last year they decided to punt on that question. And so it is up to the legislature to protect the separation of powers through reforming the statute. Now, one potential way to do this is to create a pandemic plan, a response plan that the health director or the governor has to follow the next time a pandemic arises. In fact, many people don't know this, but we had plans in place when COVID-19 hit. And this is what should have happened. These plans should have been followed. But for reasons that I am not aware of or that I've never heard explained, the Whitmer administration simply threw these plans out the window and made up their own response on the fly. The legislature, though, could require the health director and the governor to follow such a plan. The legislature could determine what is included in this pandemic plan. It could precisely define what types of unilateral actions are allowed and under what conditions. It could limit how long these orders could last, and it could balance civil rights and individual liberty with the state's emergency authority. It should grant clear boundaries around what the director can and cannot do when issuing epidemic orders. The health department will tell you they already have a pandemic plan, and it's true they have one. They have updated it just last year, actually, and I read through it. And the problem with it is, though, that it is not really a plan at all. It endorses lockdowns. It endorses some of the most controversial things that the Whitmer administration did in response to COVID, things like restricting access to medical services and things like that. And it endorses this ad hoc, make it up as you go kind of response instead of a planned, prepared response. Much like problems with the state statutes that I've outlined here, the department's current pandemic plan is broadly worded and vague. And because of that, it really allows state officials to do whatever they want the next time a pandemic strikes. So it really acts as no plan at all. And the result of this is that the next time we have a pandemic, if we don't fix things, if we don't make a plan that we can use, the response is going to again be unpredictable and controversial and chaotic like the last one. Using a prepared and planned response during a pandemic has many benefits. Such a plan can better reflect the interests and values of Michigan's diverse population. It can incorporate views from people and interests all across the state. A planned response can be more thoughtful and thorough, developed without pressure by cool heads. It can intentionally include bipartisan participation and input. Using a planned response is good for state officials too. It relieves them of having to take responsibility for the outcomes of a pandemic, the health outcomes of a pandemic, which one lesson of the COVID-19 experience is that the outcomes are largely beyond the control of public officials. Instead of trying to be judged by the health outcomes of the pandemic, officials would instead be measured based on how well they executed the plan. Another important thing to remember as well is no one can predict when the next pandemic will strike. When deciding what unilateral authority to allow during a pandemic response, I recommend policymakers should imagine handing these powers over to their most distrusted political opponent. That's who you should have in mind when thinking about how much power we should allow through emergency authority. This helps illuminate the importance of placing limits on these powers. A planned response creates clear guardrails around unilateral authority and prevents against the weaponization of government. To close, I want to offer you some hope and encouragement. You're not alone in looking at this issue. Just within the last few months, these books have been published by academic presses. One of them is by a pair of Princeton professors. The other is by some law professors at Rutgers. And the third is by a journalist. And there is an increased interest in looking back at the pandemic response across the country and in states and learning the lessons that we need to learn to make sure that the mistakes that we made then are not repeated. So I really appreciate your focus on this important work. If Michigan doesn't protect against the weaponization of government by maintaining checks and balances during emergencies, it will only be a matter of time before these extraordinary powers are abused again. And if lawmakers fail to reform the state's epidemic powers, the next pandemic will be just as controversial as the last one, which is something we should all try to avoid. Thank you, and I'm happy to take any questions.
Thank you for your presentation, Mr. Van Beek. Representative Pahutsky.
Thank you, Madam Chair. Thank you for being here. It feels a little bit like a throwback today, so I apologize.
Sorry about that.
You're good. You're good. Busting out my microbiologist chops again, first time in a while. I understand your point about epidemic not being defined in statute. Are you aware that's a scientific term? Like, we don't define every single thing that's in statute. Are you aware that that's a scientific term, and do you know the definition?
Sure, yeah. And there is a definition in administrative rules that the health department has created. So I'm aware of that definition, but I think the legislature should put its stamp on what it means by epidemic, and especially in light of
it's not a matter of what anyone means. Like, that is an actual definition. Are you aware of the difference between an epidemic and a pandemic?
Sure, yes.
So you understand that just because COVID was no longer deemed a pandemic, with some, differing opinions even on that, it can still be an epidemic in the state of Michigan, particularly in nursing homes.
Just within nursing homes?
That's literally the definition of an epidemic. It's within a community.
Oh, within a community. Okay. And the community is the nursing homes?
In this case, sure, could be.
Okay. Yeah, sure. I'm aware of that. Yeah.
Okay. So your assertion that there shouldn't have been even an offer of COVID shots, COVID vaccines in these settings, because that was an infringement on some type of authority. I don't believe there's a statute saying that the House Business Office is required or not permitted, or whatever the case may be, to offer flu shots, COVID vaccines, any of those things. Is that infringing on some type of legislative authority?
The fact that they're not required?
No, they do. So is that some type of problem?
No, I don't think that's a problem. The concern I have with the epidemic order that was issued in October of 2022 is not about what it tried to accomplish by by requiring nursing homes to offer the COVID shots. It's more about how it was used and when it was used, because at that point, it's hard to make the case that there was an ongoing epidemic that needed an emergency response.
Okay. I mean, my professional opinion is that there still was, and we regularly offer vaccinations in those settings and hospital settings regardless.
Sure.
The last point that I just want to make is the 3 statutes that you outlined as being particularly problematic. I think that there is, a argument to be made to perhaps revisit those, but who passed those to begin with?
Who passed them? Previous legislatures.
Okay, so the legislature empowered the executive branch and the subsequent departments under that executive branch to do a thing, and in some cases then repealed other laws based on how the response to COVID-19 went. But we're saying that it's somehow an infringement of the separation of powers for the executive branch to use powers vested with them by the legislative branch.
Yes, it's a problem created by the legislative branch. Yes.
But then that's not a power grab by the executive branch. That is something that they are using that was vested with them.
Yeah.
So then what is the point of what you just said?
So maybe it would help to separate the issues. So one issue is that the statutes are written in a way that is so broad that they can be expansively used by the executive branch.
Sure.
So that's the legislative part of the problem. The executive part of the problem is different, is how they use them, how they interpret the statutes, and how they actually put them to use. So those are two separate things. The legislature definitely has a role in this. All of those statutes, actually, thanks for bringing that up, because I just putting this together. They were all passed in the late 70s. So they're about almost 50 years old. They definitely should be reviewed, I think, at least at some point.
I think that's right. My one concern about the pandemic plan that you proposed is you're right. We don't know when the next pandemic is going to hit. There's some whatever. This is going back into like my old life. So, but we also don't know what that pandemic is going to be or what method of transmission. So I do think that it's difficult for us to come up with an overly prescriptive plan. Like, it's worth noting, the one that you used an example is an influenza pandemic response.
Mhm.
Regardless of what some people want to believe, the coronavirus and the influenza virus are two separate viruses. So it is difficult for us to just do a uniform, because you don't know if it'll be blood-based. You don't know if it will be transmitted more by touch. Like that is a little bit difficult for us to do. And I do think that there is an argument to be made that the legislature, while those statutes might need to be adjusted given the time that's passed, the legislature was attempting to have public health experts make those decisions because we are not necessarily equipped to navigate any variety of public health concerns that may appear.
I totally agree. Thank you for bringing that up. It's not going to be an easy thing to create a good, effective plan, and it will have to be a balance of giving some flexibility to public health officials, some discretion for them. But I think all of that, we would be better off if all of that was spelled out in a plan before the next pandemic hits. I totally agree that you have to make different kinds of responses based on the type of pandemic it is. But I will say too, though, that the pandemic plans that were in place when COVID hit, they had some of those elements too. So they had a customized approach based on what type of pandemic it was. So I think that's doable. And I don't mean to suggest it's easy to do. I will say, though, that the legislature can get input from public health officials while they're deciding what could be in the plan. That would be a very good idea too. So public health officials wouldn't necessarily be, shut out from that, creating that document. Yeah.
Thank you. Next, Representative Shriver.
Thank you, Chair. Regarding the APA Act, that's redundant, the APA of 1969, repealing that, I'm told that it would be 75 to 100 bills. And I'm not necessarily sure that that would even do the trick as far as what we need to do in terms of restoring rulemaking power to the legislature and the people. And so my question to you is, what would you recommend in terms of replacement? And then what would it look like to fully repeal the APA of 1969?
That's beyond me, what it would look like to repeal all of that. I haven't considered that before. I'm mainly just focusing on the section of the APA that allows for these emergency rules to be issued. I think the best way to reform the APA along those lines is to require some sort of procedural requirement for an agency. So some emergency laws require the legislature to approve of these emergency rules, or court, or someone else in state government. I hesitate to make it be the governor because they're just part of the executive branch as well. And so, in reality, most of the things that directors do, they have the approval of the governor for. So I don't think that's a good check, but that's what I would do. I would put in there a procedural requirement. Maybe there should be some thought given to if a year is too long of a time to allow these emergency rules to exist. And then there might need to be some kind of mechanism to penalize agencies who use these emergency rules inappropriately. As I mentioned, there's lots of examples of them using them for things that are clearly unconnected to public health, welfare, or safety. And in those cases, I think there should be some kinds of consequence for an agency that does that. To my knowledge, there isn't any.
And I couldn't agree more as far as the emergency powers and the way that the APA gives way too much authority to these departments. Whether it's this instance, that instance, or the third, all of these state departments are creating and enforcing their own rules. They've been doing it for decades and decades. And Article 6, Section 28 of our Constitution says that agencies operate under legislative statutes. And so, really, you have a stockpile of enabling laws. To agree with my colleague over here, yeah, this has been a steady reallocation of power from the people and the representatives over to these unelected bureaucrats. And so it's going to be a heavy lift in order to restore that rulemaking power and roll back some of these enabling laws. And I appreciate you being here to really establish that baseline and guide us on how to best accomplish that. So thank you.
Yeah, let me add just one more thought. It may be even broader than just reforming the APA, because the statutes that empower and create these agencies often have very broadly worded scope of authority for the agencies. And I think that's where they can point to that to allow them to issue emergency rules that apply to a wide variety of things that the legislature probably didn't intend them to regulate.
Thank you. And I just have a quick question. So after businesses were allowed to reopen after this pandemic, the health department they were putting forth rules on different industries, and some of the rules, like sanitation protocols that they were putting forth in certain industries, were actually lower than our normal industry standards. Can you elaborate on that? If the health department did consult with Laura or even stakeholders or business owners and making up these rules, because in the salon industry, for example, the method which they wanted us to keep our businesses clean was considerably lower than our industry standards.
Yeah, I think that's a problem that occurs from the type of the strategy that was used to respond to COVID, which was not to use the plans that we had in place, but to design this response on the fly, make it up as you go.
Mhm.
And that's really difficult to do. It's really difficult to pull off.
It was chaotic.
Yeah. And even if you can pull in as much other voices and opinions as possible, doing that all ad hoc is really difficult. And that's, it's no wonder why the administration had to create more than 1,000 responses to frequently asked questions. It's because those orders were they were inadequate because they were trying to do something massive that's very difficult to pull off.
And that's why we're looking at this now. Because
Exactly.
we know that there are many things that need to be addressed, but ultimately our goal is not to put the public at risk, but to put guardrails within our government to ensure that in this, if we ever have, God forbid, if we ever have this situation arise again, that there's clarity for the citizens of Michigan, there's guardrails for our government, and just to try to avoid the chaos and confusion. And sometimes when the wrong people are in power, I mean, that's a problem if they don't have clear and concise rules of what they are allowed to do. So my second question is, do you believe that the Michigan's judiciary fulfilled its role in checking the executive during the COVID emergency response? And if not, where did they fall short?
Well, ultimately, the Michigan Supreme Court did rule against the initial response from the governor and her use of the 1945's Emergency Power Law and her use of the 1976 Emergency Management Act. I'm really disappointed, though, that the Supreme Court decided not to hear a case against the epidemic orders because there needs to be clarity there, and they are well positioned to provide the clarity on what that statute means and how it can be used and whether or not it's constitutional, to be honest, because on its face, it suffers from the same problems that the 1945 law that the Supreme Court ruled was unconstitutional. Right? It doesn't provide any standards or any constraints to how this power can be used. It leaves all of that to the discretion of the health director, to an unelected state official. To me, that's the biggest disappointment. I think they should have taken up that case. They didn't take it up because they claimed it was moot. And they said that it is unlikely to happen again. So I am hoping they are right, but I am not confident at all that they are right.
Very good. And after the Supreme Court made that ruling, our governor would it be fair to say that she just used her departments to keep enforcing those pandemic orders, that she no longer had the authority to enforce herself, like the health department and their unlimited power during this pandemic was just frightening and devastating at the same time.
Yes, so she was able to just switch to using different authority in the public health code, and those are the epidemic orders that I'm talking about.
Mhm.
So initially, she was using the 1945 law
Yes.
and the 1976 Emergency Management Act, but the way that she used those was illegal according to the Supreme Court. So she switched to using epidemic orders. I think there was a period of 3 days where her original orders were unconstitutional, and before the new epidemic orders were issued.
Thank you.
Yep.
Representative Wagala.
Hi, thanks for being here. I think this is really interesting to me. I just want to recognize, I think, this is weaponization of state government committee. So I think this is an important topic. I don't know if I would agree that the use of the emergency powers and then the subsequent Supreme Court rulings should be considered weaponization. I think, to me, that's, you're trying to harm people, et cetera. But is it your opinion that the government was weaponizing its powers? Because to me, that implies that there's a negative intention or that from the government, or do you see it more as there was a serious situation and the government was doing what it felt was best in the moment?
Yeah, no, I would say I had kind of a broader idea about this, which is really the separation of powers is there to prevent one branch from exercising authority that it shouldn't, and for doing something then that's not its public duty. So anything outside of that public duty, in a sense, could become weaponization. It doesn't have to be, but if we have, I think the most concerning thing for me is we have statutes in place that allow for this kind of thing to happen, and so hopefully we have state officials who are not going to do this. But if we leave it all up to them, then we're at risk to a certain extent, and the legislature could make it so that it's less likely that state officials could use these powers to weaponize government.
And the reason I ask is because it is easy for us to look back, I think, now and realize that everything that was done at the time might not have been perfect, right? I think we
Sure.
should all be able to recognize that. But CDC statistics, I mentioned this last time, I think it's 1.2 million people have died from COVID-19. A lot of people are still dealing with long COVID to this day. I know personal people that are dealing with long COVID. It's serious, and I think what is really difficult as we move through this, I'm not saying we shouldn't be better prepared, but where is the line? And I think this is where we as a committee have to figure out, where's the line between executive authority and emergency powers and then congressional authority? Because with pandemics, sometimes they come just like that. And, whether we're prepared for them or not, there's no scenario where we're going to be 100% prepared. So a little clarity from you, I'd like to hear about where you think that line is, because I think right now we're especially seeing in this country, things are being declared emergencies all the time. I mean, federal government right now has declared the International Emergency Economic Powers Act to put the tariffs in place. And I don't think that there's an emergency to justify that action. So I would just love your thoughts on where we go.
Completely agree. This is a problem
And if
that
I could,
is.
I'm very sorry. And if
Yeah.
we could keep our comments and questions relevant to the state of Michigan and this topic, that would be great. Thank you.
Yeah, I agree. It's a problem at the federal level too. And where to draw that line, that's why you all got elected. That's the difficult thing for you to decide. I think looking back at what we did during COVID. I think for many people, they felt like the line was too much towards the executive branch, where, I mean, really the legislature had no ability to do anything, to have any input at all into the COVID response. So is that where we want the line? I don't think so. I think the legislature needs to be involved at some point. I agree. There has to be some way for the executive branch to act immediately. And, you know, the EMA's 28 days is a good example of, okay, this is 4 weeks of unilateral control that the executive branch could have. And then the legislature has to get involved in some point. That worked during COVID, actually. If you remember, the legislature did extend the governor's emergency powers under the EMA one time. So I think it was for 45 more days. So that can work. I think that's a pretty decent model of getting the legislature involved. But, you know, that's why I think a plan would be useful, because those in that plan is where you can start to draw some of those lines of exactly where you want the authority to be during these emergency situations.
Thank you. Representative Wolford?
Thank you, Madam Chair. Appreciate you being here today. Thank you so much. And these are my words, not yours. But thank you for reminding us today of the fourth fictitious branch of our government, the administration state, that unconstitutionally ruled over a free people. I think it's important for all of us here to remember that we don't work off opinions. We work off the Constitution and the law, especially as lawmakers. My question for you is, do you think that MCL 333.2253, which grants epidemic control authority, do you think it gives too much discretion to unelected officials?
Yeah, absolutely. Like I said, that statute suffers from the same problems that the 1945 law that the Supreme Court ruled unconstitutional. It has the same design flaws. It has no what the Supreme Court called standards of delegation. So the director can use that statute to grant himself or herself unilateral authority based just on their opinion, and that unilateral authority can last indefinitely. And there's no procedural requirements that the director has to go through to use that unilateral authority. So to me, it's one of the most sweeping ways that a state official could give themselves extraordinary power.
For instances, like you mentioned, who can be in your house? Could you give us a few others?
Yeah, well,
examples
I
of
mean,
that?
we all remember these, I think, from COVID-19, some of the orders that, you know, the epidemic orders were used to just continue on the executive orders that Governor Whitmer had been using before the Supreme Court ruling.
Mhm.
So yes, it limited personal gatherings. It was used to close schools. It was used to require
Our military to take the shot or get kicked out.
yeah,
That's
I think that
facts.
was a federal. I think
No,
that
it
was
was
a
at the
federal
state
thing.
level
Yeah.
too,
Okay.
National
yeah.
Guard.
Yeah,
Yes,
I
thank
could
you.
be- Yeah, I'm not aware of that one, but
Yes,
yeah.
sir. Thank you. And then also, you'd mentioned that the pandemic, whatever words we want to use, orders had no duration limits. How does this affect transparency and public input during the COVID-19 response?
Yeah, I think the durational limits are really important, and for the standpoint of people who are under these rules, who are now required to change their behavior in ways, change their everyday behavior. Not knowing when this will end creates anxiety, and I think makes people upset, and it makes the orders more controversial. So I think every emergency order should have in it an expiration date of when it is going to expire. The Whitmer administration initially didn't do that very often, didn't put in an expiration date, but over the course of the pandemic, they did more frequently. So I appreciate that about them changing their approach and putting in the expiration dates and letting people know that, you know, there is a plan for this to expire and this is temporary. But if there is no expiration date, you know, we don't know what's coming next.
So last question and closing for my questions. So this really doesn't have anything to do with influenza or COVID-19 or whatever it is. I mean, specifically, it could be a broad number of things that the administration state can deem an emergency. Is that correct?
Yes, that's one of the problems with these statutes is they're so broadly worded that they could be used and applied for any number of circumstances.
Thank you. Do any other states have better models for handling executive power during emergencies that Michigan could maybe emulate?
Yes, absolutely. So many other states have reformed their laws since the COVID-19 pandemic, actually. Some states have, I know Pennsylvania, for instance, passed a constitutional amendment that restricts the executive authority to 28 days, I believe.
Okay.
But other states have modified their statutes to put guardrails and safeguards in place and to further define when these powers can be used and for how long they can last. So yeah, there's lots of examples from other states that that Michigan could use to model after.
Okay. Perfect. Thank you. Representative Pohosky?
Thank you, Madam Chair. Are you familiar with the Uniform Law Commission's plan? It was released in 2023, so it's fairly new,
Yes.
but they examined everything. So is there anything that you think would be useful out of that? Or rather than try, because I think their whole goal is to avoid this patchwork of different state laws should this ever happen again. Well, when it happens again. So have you looked at that?
Yeah.
And what do you think of that?
Yeah, actually, I was invited to help draft some of that as part of that commission, and I haven't looked at it recently, though. I don't remember what the final product was. But that's a great idea. I think there are other things that we can use to model what our emergency power statutes should look like, and that's a good example of one. Yep.
Representative Wolford?
Thank you, Madam Chair. You noted that Michigan, and I know you went over this, but I'd just like to ask again, you noted Michigan has 30 emergency power laws.
Yeah.
In your expert opinion, is this a sign of necessary flexibility, or does it give the government potential overreach powers?
Yeah, so most of the emergency power laws that we have on the books, I was surprised by how many I found, to be honest. Many of them have limits into how they can be used. So most of them I don't find troubling because they either limit what a state official can do, like the actions they can take after they issue or after they declare an emergency, or they require the action to only last for a certain amount of time, or they provide some other check and balance on how this is used. The three that are problematic are the three that I emphasize: epidemic orders in the Public Health Code, the Emergency Management Act of 1976, and the emergency rules that can be issued through the APA. So those are the ones that are really should be the focus because they're the ones that have grant the broadest amount of authority and are written in a way that allows state officials to have broad discretion.
So thank you for that. And I guess it's good, right, that we have a structure and that we follow the three branches of our government and our Constitution, because technically, when the governor declared a state of emergency, I guess someone else then could have declared a state of emergency because people were depressed and suicidal during this time. And I guess I make that point to say, if we don't have something to follow, and which we do, the Constitution, we will have any and all people just making things up on the fly. Is that a fair statement?
Perhaps. I guess that does bring up another, I think, shortcoming of the pandemic response that we had for COVID, which is we had several layers of emergency declarations and orders coming from the executive branch. So even while the governor was issuing executive orders, the health department was issuing epidemic orders that reinforced the executive orders, which I'm not even sure how that works and if that's legal, but that's what they did. And I think all of that added to the confusion and the controversy over how the public was supposed to respond to this pandemic and what requirements were made of us and what sort of things could we do and what was legal and what would get penalized and what wouldn't. So I think a much better response would be to have a plan that's already prepared and a single source of authority, and you just execute that plan. And that would reduce the confusion, reduce the controversy, I hope. But if we leave things as they are now, I know for certain that there will be legal controversy again during the next pandemic response, because the health director will use these epidemic powers again. And as I said, on their face, they look unconstitutional. So they will be challenged in court again, and we'll have to wait months and months to figure out what is legal and what is not while a pandemic is going on, which is, I think that's the thing that we should want to avoid the most, and get this figured out before we find ourselves in this situation again.
Thank you, sir. Thank you, Madam Chair.
Thank you, Representative Wagala.
Hi, just want to clarify, I'm not a scientist, never claimed to be one, and a huge believer in the Constitution, huge believer in eliminating executive power. But I think one of the things that makes this conversation so difficult for me is, like, during a pandemic, I truly believe my constituents would believe that scientists and doctors are the ones we should listen to and trust those opinions over maybe those of some legislators who might not agree with scientists and doctors. And the reason I bring that up is because how do we create this balance of allowing our experts, people at these departments, to respond in an appropriate fashion in an emergency situation quickly, with also the balance of making sure that the separation of powers exists and that there isn't the ability for government overreach. I think it's such a nuanced and complex discussion, honestly, and which we won't solve in this committee, but maybe we can outside of here. But I think to me, that's something that I have real interest in, because things move so fast in 2020, right? I was scared. I think a lot of Americans were at the time. I was a teacher, so my students were scared. How do we appropriately design a law that allows for both? And is that even possible?
I think it's possible. Again, it's not going to be easy. I agree that experts and public health experts and scientists need to be involved. But I will say, though, that when it comes to a pandemic that influences all of society, scientists and public health experts are not experts in all of society. They're experts in their fields, and we need their expertise, absolutely. But we need to draw in from a broader set of voices and expertise, because the pandemic influences everything, right? I mean, it influences businesses and schools and churches and everything, every part of life. So we need to draw in from an even broader perspective of expertise than just public health experts or scientists. Not to say that they're not valuable, they are, and they need to be a part of it. But ideally, and I think through a prepared plan, you can draw in from a broader range of voices and expertise on how best to respond to the next pandemic.
No, I appreciate that. And I think I agree. And I wouldn't suggest that anyone at the time wasn't listening to various different stakeholders. But I think where I'm kind of nailing down on here is, I imagine the reason for all executives that emergency powers exist, and the reason that legislators in the past have given them, is because we're a partisan institution here in the legislature, and it's hard to get us to agree on stuff. So when time is of the essence and lives are at stake, I think that balance is just it's a difficult thing for us to figure out. But I appreciate the fact that we're looking back and trying to digest what happened and where to move forward. So
yeah, I think a plan, having a plan could allow for that, because to get that bipartisan perspective into the pandemic response is really, you're right. It's not possible to do in the heat of the moment, right? So we need to do it now before the next pandemic, so that we have that ready, we have that perspective ready when we're going through the next emergency.
Thank you. And to kind of piggyback on what you're saying, that's kind of why we're here, because we don't want the fear and everything that happened during the pandemic. When government moves swiftly, grave mistakes are made. And, we obviously need to address this and make sure that we have a plan so we're not living in fear while protecting people's rights. And those are the two most important things. And I would not disagree that there were a lot of tragic deaths during, this period of time. But we have to make sure, number one, that the government has guardrails. That's the number one thing we have to make sure. And for people to be able to make their own decisions based on what they see fit in their health, whether they would like to get the vaccination or not, that should be their choice. But to lock children out of their schools, to lock people in nursing homes, to not allow people to visit their loved ones, there were so many things that made absolutely no sense. That was a grave overreach of government, from not being able to buy paint or landscape supplies. You could use a boat with a motor, or no, excuse me, you couldn't have a motor. You'd
That's
have to
right, yeah.
row your boat. When you would go into a restaurant, you had to sign a tracking sheet. I felt that was a grave, infringement on my rights. To have any government agency knowing where I've eaten lunch that day, to me, was very uncomfortable. And the masking situation, I have 2 children that cannot be masked for medical reasons. And I had to homeschool my children for an extra year. That wasn't my desire. I wanted my kids in a social setting. Are there studies out today that can give us kind of how the state's recovered as a whole since that period of time? For instance, the mental health status of our teens, the maturity level of our young youth, being being denied their social interactions, their sports activities for up to 2 years. I've spoken with many health professionals, and even within our school systems, that the maturity level of our teenage kids now is 2 years behind. My third son is 15. He does not have the maturity level of a 15-year-old. We have increased suicide rates. How many businesses never reopened after COVID? Do we have this data that will help us as we address this plan? And I look forward to working with my colleagues in this committee and beyond this committee on addressing a plan moving forward.
Yeah, there's a lot we can learn, and we can learn from what Michigan did well and what it didn't do well, and we can learn from what other states did. I mean, one of the good things about the design of our federal system is we have 50 labs of democracy, right? Where we can, 50 states did things slightly differently when it came to the pandemic, and we can learn from that. In fact, this first book that's there, In COVID's Wake, by a couple of professors at Princeton, I just read that, and that's what they do a lot of, is compare the outcomes in states based on their pandemic responses. What they mostly find is that it didn't make a big difference if a state was tightly closed and locked down, or if a state was wide open. Their experience with COVID was very similar, regardless of the rules that they had. So that's one thing that we can learn. I'll also just say, some of the orders that we had that seem to us now to be kind of silly, I think are a result of this approach of trying to make up the plan as you go. If we had a prepared plan, we could decide now, how long should schools be closed? Should we allow boats with motors or not? Should we allow people to walk on a golf course but not golf on a golf course? Those kinds of things we can get figured out now, so that when the next pandemic happens, we already know what's the public health officials are allowed to do and what they aren't allowed to do. And we can be prepared, and it can be less controversial. Hopefully it will lead to less anxiety and less fear amongst the population as well.
Yes, thank you. And I think that it's important that we look at the scientists and the health professionals that the government had entrusted at that time, because it was kind of all over the board. And it became apparent that some of these doctors were very interested in being in the spotlight and things like such as that. And it's just not appropriate during that period of time. So, Representative Pohodsky.
Thank you, Madam Chair. I just wanted to go back to something earlier because then it came back up in a question. Under the APA, it requires that the governor declare a state of emergency. So in that instance, correct, it's not just that any department can go and start issuing emergency rules. It does require a declared state of emergency.
No, that's not quite right. The governor has to sign off on the emergency rules, but it's the agency that finds the emergency.
Correct, but the governor has to concur in
Yeah.
the finding of an emergency because you left that part out. So, I mean, I think that's sort of a distinction without a difference. The governor still, like, it's not as though an agency can just start issuing rules. There does have to be a secondary check on that.
Well,
We can talk
yeah.
about whether or not, in this case, there was, disagreement about all of that, and particularly as it progressed throughout the course of the pandemic.
Yeah.
But it's not as though, you listed a number of agencies. They can't just, of their own authority under the APA, start issuing emergency rules.
They can, as long as the governor signs off on it.
So not of their own authority.
Well, yes, but that is the executive branch checking the executive branch. What would
Yep,
be
I'm
what
not
would be
debating
better?
that. I'm
yeah.
just saying the ellipses dots you had on that slide were doing a whole lot of heavy lifting. And I think that it created some confusion based on some questions we got about who all has to be involved in that decision. So thank you for clarifying.
Yeah, just the executive branch. Yeah.
Thank you, Representative. Representative Shriver.
Thank you. Can you go back to that slide that contained images of the, yep.
Okay.
We're on the same wavelength. So how much of this whole issue is an issue of who is governor? There were 7 states out of 50, 7 governors out of 50 that did not issue statewide lockdowns. Fear had a lot to do with this. Pressure, public pressure, party stuff, But at the end of the day, there's one common denominator of these 7 states that did not issue statewide lockdowns. All 7 states had Republican governors. And so you have your plans here, and we could make a better plan. But what's going to stop a rogue governor from just side-skirting the new plan? And so, again, my question to you, knowing that only 7 out of 50 governors did not issue statewide lockdowns and all 7 were Republicans, how important is it who is governor during a pandemic when it comes to a state's response?
It's very important if we continue to have, if we have the same system as we have now, because it leaves to whoever is in governor, whoever is the health director, it's up to them to decide what we do. I would rather have it be less partisan driven and have it have a plan prepared beforehand so that it doesn't matter who is governor. There is a plan in place that's been prepared by public health officials with the insight from the legislature, with input from a broad selection of the population. And in that case, the goal is ultimately to have a plan in place so that it doesn't matter who the governor is or who the health director is. We will know how we're going to respond based on that plan. My guess is, I suspect what we would have to do in order to not allow a governor to just toss the plan aside is to require it in statute somehow. So that would be my suggestion.
Thank you.
Representative Wolford.
Thank you, Madam Chair. I got to be honest, I feel a little foolish today because I didn't, has COVID or the coronavirus, it's been eradicated? Is that right?
No, it's still around.
Still around. Okay. There's some people who got a shot, some people who didn't get a shot. and this still exists. So this should be a reminder to all of us on this panel, those that are listening, and the citizens, that we have to get back to not allowing a governor, when she's held to the Constitution, to unconstitutionally shift powers to the admin state. So thank you for reminding me that this COVID and coronavirus still exists, yet we're functioning as a society. No one's being locked in their home. The list goes on and on. Thank you again for being here, sir.
You're welcome.
Thank you. Thank you for being here today. It's been eye-opening, and I know that not all of us on the committee see eye to eye on certain things, but I think I can't speak for you guys, but I can't speak for you guys. But to say that, I mean, I think it's fair to say that we need a new plan. We need a new emergency plan. We need to make sure that things are transparent, and that's kind of been the theme of this term, is bringing transparency and oversight back to government. I appreciate your presentation. Hitting on the points of separation of powers is fundamental to preventing any government overreach, and that Michigan law has allowed state officials to assume unilateral control during emergencies. We definitely need more clarification. The executive branch can act without legislative oversight via 30 separate emergency powers statutes. And of course, the epidemic orders have lacked, scope limitations, limits, and procedural safeguards. And we are definitely going to commit to proactively crafting legislative emergency pandemic response plan. Now is the time to do it.
Absolutely.
Especially in a bipartisan government. I think working bipartisanly on this is very important, because I don't believe that one party should rule our government. We see what the oppression that's caused in the past, and bad policy that's come out of it. So I think, this is good. It's, we're looking at pro-Constitution. It's not anti-health. It's not anti-health at all. People did die during the pandemic. A lot of mistakes were made, and people were fearing not just the virus, but people were fearing their government. The number one Googled term during the lockdowns was the Constitution. I think a lot of people really woke up during that time to get a better understanding of their rights, and learn that their rights ultimately don't come from the government. They come from God, and it's the government's responsibility to protect those rights. So yeah, we definitely need to highlight accountability, transparency, and equal branches of government. And I think that will definitely serve us better, serve the residents of Michigan better in the future. So is there anything we have a few minutes left. Is there anything that you'd like to add that we may have missed?
I could talk about this stuff all day, but
Sure.
but no, nothing in particular right now.
Okay. Well, with that being said, there'll be no further business before the committee. We'll stand adjourned.